Good afternoon, everybody.
Good afternoon.
All right, welcome to our second Skills and Context session. Whereas in the first session, we talked about how to analyze PJ using the coggle. This session is geared towards the skill of organizing an essay. Quite a number of you have come to see me and you show me your practice essays, and I can see that you put a lot of work into them. But I can also see that many of you are struggling, quite understandably, with the problem of getting what's in your head down on the paper in an organized way that hits up the main issues, counter issues, sub-issues, and the like. So what we're going to do today is focus on that skill of getting down on the paper what's in your head. More specifically, how to organize essays in civil procedure in my class. Now, as you know, I put together a handout on tips and techniques for Civ Pro exams, so let's start off with that. All right, we've talked at length about IRAC and FIRAC and IFRAC, and you can go back to the handout on the website about IRAC, IFRAC, FIRAC, all of that. As you know, it's the structure of court opinions, of your briefs, and of your essays. The difference between a court opinion and an essay answer is that you don't just tell me the story. You don't just give the facts. The facts are relevant only in that they're part of your analysis. So you do IRAC. Well, when the professor's telling you that you ought to do IRAC, it would be very natural for you to conclude that IRAC is a rigid formula that I will use in structuring all of my essays, regardless of the number of issues, regardless of the number of sub-issues, regardless of the nature of the facts, and regardless of the nature of the law that's at hand. Were that to be your conclusion, that would be a conclusion made in error. IRAC is not a rigid formula to be used in all cases. Take, for example, the simple fact pattern that I asked you to look at for today. With simple subject matter diversity fact pattern, right? You have Peter, born in Russia, moves to New York, he's a lawyer there. Eventually he buys a vacation home in Miami. He doesn't plan to retire there for 10 years yet, but he does go there from time to time. There's Deborah, born and always lives in Florida, and Deborah is alleged to have slandered Peter, causing him to lose his business. Peter sues Deborah in a federal court in Florida. The call of the question, is there subject matter jurisdiction in federal court for this lawsuit? Pretty simple fact pattern, right? I'm sure the vast majority, hopefully all of you, would conclude in class that the answer is there is subject matter jurisdiction. The amount in controversy is listed as $100,000, which seems more than reasonable for somebody who's lost their reputation as an international lawyer. Parties are also completely diverse for reasons we'll discuss later. I'm sure all of you read this and thought, well, duh, of course the parties are diverse and the amount of controversy is met. Therefore, there's SMJ. But a number of you have come to me with answers to this fact pattern, and I've noted that you have long paragraphs, or you're missing issues, or you're dropping issues, or you're jumping from one thing to another, right? So the reason I have you start off with such a simple fact pattern is to realize that organization is important, and one of the keys to organization is practice. Another key to organization is outlining ahead of time, thinking about how you would organize various issues and sub-issues were they to come up. Now let's think about this fact pattern for a minute, and we're going to see that there's a lot of sub-issues here, right? Deborah is born and lives in Orlando, Florida, right? She always lives in Florida. She's a citizen of what? Which state? Florida. Okay, so we have to figure out citizen of a state regarding Deborah. The answer is pretty obvious, but you still have to give the law and analyze it, right? Regarding Peter, Peter was born in Russia. You should start thinking, is he an alien? But he became a U.S. citizen in 2005, so now he's a citizen. He's lived in New York, near his New York law offices, since 2002. That suggests his birth domicile of Russia was changed to New York, right? Since he's a U.S. citizen who was domiciled in New York, at least as of 2002, he was a citizen of New York, right? Parties would be diverse. You can also have to deal with the thorny fact that he has a condominium in Miami Beach that he goes to every summer and plans to eventually retire to Florida, right? So one of the hard questions here is going to be, is Peter a citizen of Florida or is he a citizen of New York? For reasons we'll discuss later, the better answer is he's a citizen of New York, right? But that's going to be something you're going to have to discuss. Now think about all the law attendant to analyzing that, right? Do we think that he's a foreigner? No, it's clear that he's a U.S. citizen, so you wouldn't analyze alienage jurisdiction here at all. So what would be at issue would be 1332, subsection A1, diversity, a suit between citizens of different states. So think about all the sub-issues for citizen of different state, right? To be a citizen of a state, you got to be a citizen of a state equals a U.S. citizen plus somebody who has domicile in a state of the U.S., right? Domicile, in turn, means you have residence plus the intent to remain. And then intent could be in three different flavors, right? There's the Mawes permanent test. There's the Gordon intent to stay indefinitely test. And there's the Sadat for the time at least test. Now look at the call of the question here. If authority is split, use the majority rule. What's that?
For a second.
Because there's three different views of the law, you would have to analyze all three. But the careful student reads the call of the question and it says use the majority rule. Now, of these three flavors of intent, which one is the majority rule? Which one? Indefinitely. So you wouldn't even analyze these two, right? But now think about this. To figure out the citizenship of Deborah, you'd have to analyze all that stuff. Is she a U.S. citizen? Is she domiciled in a state? Where does she reside with the intent to stay indefinitely? You'd have to give the rule. You'd have to analyze it. And then for Peter, you wouldn't have to repeat the rules if you already said it, but you'd have to analyze the rule for him as well, right? All of that stuff. And then when you get to Peter, you have quite a lot to analyze because you're going to have to consider the argument that he's a domiciliary of New York versus the counter-argument that he's a domiciliary of Florida, right? It's quite a lot of stuff to organize, isn't it? Now let's think about the amount in controversy. It's listed as $100,000, right? Well, we know the amount in controversy has to be over $75,000, not counting interest and costs, so you'd have to list that, right? But we don't just take the plaintiff's recitation of the AIC blindly. Additionally, we need to apply the St. Paul Mercury test, right? Which says we take the plaintiff's amount if pleaded in good faith, unless the court is certain, a legal certainty, that the amount in controversy won't exceed $75,000. Okay, now we haven't even organized this yet. All we're doing is issue spotting. And look how we're marking this up, right? So we have Peter, you should be thinking Peter, New York. Is he Russia? No, that's pretty clear. New York, possibly. Florida, possibly. Deborah, Florida. Mountain controversy, is it met? Now think about the IRAC. I say all of this by way of introduction. IRAC, let me make this a little bit bigger. There we go. IRAC is not something to be applied blindly. Think about the issue here. What is the issue for that question? What is the issue? What is the issue?
For that hypo?
Yeah, for Peter, Sue's, Deborah.
Oh,
What was it?
PJ.
Is there PJ?
Yeah, SMJ.
Is there SMJ? Yeah. It doesn't have to be long, right? Does the federal district court have subject matter jurisdiction in Peter's lawsuit against Deborah? Boom, you're in and out. And what's the ultimate conclusion here going to be?
Yes.
There, for the reasons discussed above, there is SMJ in the lawsuit against Peter versus Deborah, right? Now, in some cases, your conclusion might be contingent, depending on sub-conclusions or depending on which version of the law people used, or it might be debatable. So if your conclusion is actually contingent or tentative, point that out in why in your conclusion. But in this one, it's very simple. Issue, is there SMJ? Conclusion, yeah, right? I mean, I wouldn't say it that way in your essay, but those are the easy parts, right? Now think about the rule and analysis. A rigid blind application of IRAC would require that you list all the rules up front, and then the analysis would ignore the law and then just do analysis. Blah! Don't do it that way, that's awful. Think about all the rules you'd have to use just to analyze this simple fact pattern. Imagine having a long run-on paragraph that said something like this. For there to be diversity jurisdiction, the parties must be completely diverse. Here, citizens of different states, and the amount of controversy must exceed $75,000, not counting interest and costs. To measure a citizen of a state, you must look to whether the person is a U.S. citizen who is domiciled in a state. Domicile, in turn, means where you reside with the intent to stay indefinitely. You can throw other stuff in there, right? You talk about diversity, citizenship is measured as of the date the lawsuit is filed, right? And is not defeated by things that happen after the filing of the lawsuit. You could add in some discussion of minimal diversity. Think about all the law we've talked about, and we haven't even got to analysis yet. If you do your rule statement by throwing together in a bucket with all of the law that may apply to the analysis, you end up with a rule section that's this long. Now suppose you do that. Issue, rule, everything, and then you get to the analysis, you're not going to remember what to say. You're going to forget issues. You're going to have a long paragraph of yucky analysis that jumps from issue to issue, not well organized. You're going to confuse yourself, and you're going to forget what issues to discuss in what order, because all of the rules that would apply to those analyses would have been said a page earlier in your super long rule. It's just awful. It's a horrible way to organize. You think, okay, professor, fine. You told me to use IRAC, and now you're telling me not to use IRAC. So which one is it? Well, you do use IRAC, but a real IRAC, the real structure, more accurately, depends on the facts, the issues, the call of the question, and the law, right? So what you do is you can have multiple, if there are multiple main issues, then you need multiple IRACs. Or if the main issue consists of law that requires several steps in the analysis, then you have sub-issues. In other words, you have IRACs within IRACs. Now let's think about how this might work if you were doing a simple, very simple, easy peasy SMJ essay, like question number 1, right? Or Peter sues Deborah. We already know the answer. This is why in that handout I say there's 2 skills that are needed. One is knowing the law, the second one is getting it down on paper. We're talking about the second one, that second skill, aren't we? How to get all that stuff from your head down on the paper in an organized way. All right, well, here's an example. Overall issue. Your main structure is overall issue, and at the end, your overall conclusion, right? Overall issue. Does the court in Florida, federal court, have SMJ in the suit of Peter versus Deborah, right? Overall conclusion, you state whether SMJ exists, is tentative or contingent, explain why. Neither of those have to be long. The heart of your essay is going to be the analysis, which is going to be rules and analysis, maybe sub-issues and sub-analysis, and so on. Let's think about how we're going to do this now. Now, you start off with the overall rule. You give the main parts of the diversity jurisdiction test, right? Complete diversity plus SMJ exceeding $75,000, not counting interest and costs, right? Boom. Isn't that easy? Now what you've done there, you give the main rule, and then you have 2 subsections below that with the sub-issues. Here I put them out in controversy first, and complete diversity second. Sub-issue 1, sub-issue 2. So what you've done is you've given your overall issue, your overall rule, and then you have 2 sub-IRACs below that. One for the sub-issue of AIC, amount of controversy, and the second one for the sub-issue of complete diversity. And then what you do for your sub-IRAC, you state a sub-issue, sub-rule, sub-analysis, and sub-conclusion. All right, AIC. Sub-issue, does Peter's claim exceed $75,000 exclusive of interest and costs? You still have to give more law, right? That would include the St. Paul Mercury rule, right? Good faith. We accept the plaintiff's amount pleaded so long as it's made in good faith, unless the court is certain that that amount cannot exceed $75,000, which is the jurisdictional threshold, right? Put differently, we take what Peter pleads, if it's in good faith, and it's still okay so long as it's possible for him to get over $75,000, okay? Now you get to the analysis, you then apply the law to the facts. You apply the law to the facts and counter-argue if a good counter-argument exists. And you could raise policy issues here as well. All right? So do you think Peter's pleaded in good faith $100,000?
Yes,
Why?
because he was a successful lawyer and his reputation was ruined. And
This
that's
is a
why-
successful international lawyer. His reputation was ruined. In fact, $100,000 seems rather low, doesn't it? Regardless, are we certain he cannot get above $75,000? Can we say that? Put differently, is it possible for him to get over 75? Absolutely. Okay, there's your analysis. There's probably not much counter-analysis here, so you don't go to counter-analysis unless you have a counter-analysis you can make with a straight face, right? So don't raise frivolous issues. Don't give BS arguments just so you have a placeholder that makes a counter-analysis. I will give you points for making counter-analysis that doesn't pass the straight face tests, because part of your job as a lawyer is to problem solve, all right? And a lawyer that brings up essentially BS or arguments that nobody would buy is not problem solving. They're filling space just because they think mechanically they have to give counter-analysis, right? Some issues will have counter-analysis, some will have none. All right, so you concluded that the AIC is met. Give a sub-conclusion. Look what you had. You had an IRAC for that sub-issue. Now you think about it, it's not really that hard. And why do you know that you need a sub-IRAC for AIC? Because the overall rule tells you the structure of the law. There's two main parts to the overall rule, which is AIC and the parties being diverse. You see? It's your law that determines the structure. You still use IRAC to organize the various sub-issues in your essay. However, you do IRAC rigidly. There's just only one issue, only one rule, only one analysis, and only one conclusion. No, you typically don't do that. You typically don't do that because usually the law is going to indicate whether you have multiple IRACs or sub-IRACs. I saw a hand.
Yes, for sub-issue number 2, what I did is I broke it down into 2 separate issues. Would you suggest something like that?
That's a wonderful, wonderful question. And I'm going to use your question to move into sub-issue number 2. Now, for simplicity's sake, this is how I presented sub-issue number 2, right? Sub-issue number 2 is, are the parties diverse? So you give the sub-issue, you give the sub-rule. Now, the rules you're going to give here are going to depend upon the facts, which in turn indicate what legal sub-rules are going to be in hand, right? What if, for instance, Peter was still a citizen of Russia, right? Then you'd be thinking about alienage jurisdiction. What if he was domiciled in the same state, or arguably domiciled in the same state as an opponent, and he's an alien, and he may or may not be a lawful permanent resident? Then you have to start thinking about the after comma exception to alienage jurisdiction in 1332, subsection A2. Now here, at the time the suit was filed, there's no aliens involved at all. Peter used to be a Russian citizen, now he's a US citizen, so the question here is going to be as a citizen of one state versus a citizen of another. So what you got to do here in your analysis is apply the law of the facts, analyze the citizenship of each litigant separately. Now, I think that's what I take your question to be, and the answer is yes. Now, I'll admit, for purposes of teaching you the basic skill, I've presented this sub-issue of citizenship as being one separate sub-issue. But you could actually treat them as a sub-issue that itself contains 2 separate sub-issues, right? That's your question, is it not?
Yes.
You're correct. You're correct. And indeed, you go through my past essays, and you'll see SMJ fact patterns where one of the issues is diversity, and you might have 3 or 4 litigants. Remember, SMJ, you got to analyze party by party, claim by claim, right? So if it was Peter and Pam versus Deb and Dave, right? Then it's like this, isn't it? You got 4 things you got to analyze, don't you? So let the facts and the issues and the call of the question and the relevant law indicate your organization. And just because I'm presenting one form of organization today doesn't mean that there are not other good forms of organization. You're absolutely correct. If I point out here, you want to analyze the citizenship of each litigant separately. Now what you can do to make things easier, and I actually kind of ask that you do it, is you don't have to keep repeating the law. All right? So for instance, you say, to be a citizen of a state, you must be a U.S. citizen who's domiciled in a state. Domicile in turn means blah, blah, blah. Say it once, then analyze it, say for Deborah, right? Now we move on to Peter, right? The rule's stated above. If you're worried that I'm going to forget that you said the rule, fine, just say rule stated above, okay? Please don't do this. Please don't cut and paste the rule 17 times in your essay. It makes me nuts. It's awful because my mind wrapped around it the first time you wrote it, and when you cut and paste it, I'm still going to read it to make sure that you didn't say anything different or wrong, right? But in terms of good writing, there's no need to keep doing that, right? Now maybe, when you analyze Deborah, you give some law that's relevant to her. When you get down to Peter, you say, see rule above, and then there's some additional law that's specific just to Peter, right? And you want to put that in your Peter part of the analysis, that's fine. But ultimately, you need to consider what are the issues and sub-issues and have IRACs for each. And an important point to consider here is not only do you need to state the sub-issue, you need to state the sub-conclusion. And that's good because it keeps you honest. Keeps you honest because then you're thinking about for each sub-issue, what did you actually conclude? Instead of just barfing out some, I use the word barf a lot, don't I, when I talk about essays. You want to think about your conclusion, right? Because these conclusions build upon one another. So if you conclude the amount in controversy isn't met, if your essay suggests the amount of controversy isn't met, right? But then you don't state what your sub-conclusion is, and then at the end you say there is SMJ, I'm going to be scratching my head. Let me tell you something. I used to grade essays by giving a couple points for the issue, a couple points for the conclusion, right? I don't do it that way anymore. I grade by issues and sub-issues, all right? Particularly by the discrete sub-issues. And I look, are you providing sub-issues and sub-conclusions, right? Do you give the rules in a meaningful way? Do you give counter-analysis when it's appropriate, right? So it's actually quite important to me that you organize your essay in a way that reflects that you're thinking about, here's this sub-issue, all right? Here's the rules that apply to it, here's the analysis, any applicable counter-analysis. You can raise policy if you want, but policy is like salt. All right, a little bit goes a long way. Amount in controversy, for example, it exists to help keep, minuscule and monetarily frivolous, not frivolous, but it encourages the more important claims to be in federal court, right? If something is a minuscule amount, then it's not to be in federal court unless it's a federal question. That's why we have the amount in controversy. Equally so, why do we have diversity of jurisdiction? To prevent prejudice, right, against out-of-staters, right? Why do we have removal jurisdiction, right? Well, that's to give the defendant a chance to defeat the plaintiff's choice of a court system, right? Oftentimes for reasons that involve bias, oftentimes for reasons because of preference for a court system. When we think about why the law is the way it is, we can write better essays because we actually understand the law and write more meaningful, thoughtful essays. And you should also think about ways you could vary this fact pattern. It's a simple fact pattern, but you could easily vary it up. Make it a removal / SMJ fact pattern, right? What if the lawsuit was filed in state court in New York and it was removed by Deborah? What if it was filed in state court in Florida and removed by Deborah, right? Now you have all the additional issues of removal law piled on top of the issues of diversity, right? You'd be thinking about when is removal proper, where do you remove to, you'd be thinking about form defendant rule, since here the only basis for removal would be diversity, right? So you can test yourself and test your knowledge in various ways by starting with a fact pattern and changing the facts a little bit that inject new issues into it. Now, in terms of your studies, I recommend that you, if you haven't done it already, and I think a lot of you have, but start off with the simple, where are they? The simple SMJ fact patterns, right? SA1's a pretty straightforward one. SA2 involves alienage, right? And SA3 is a variant on SA2. And that'll teach you some of the basics. Then I'd say do the easy Amazon and then do the hard Amazon. And then do the one we're doing later in this class, which is for best batteries / Y-phone, right? Do that. And then once you really sunk your teeth into a bunch of my essays, start getting ready for the real game. Do some of my exams that are actually on the website. Start doing some of those and bring them to me. I love seeing students bring me my old essays. Sometimes I have to take a few minutes to remember what the facts and issues were, but it doesn't take me that long, and it's excellent preparation for you. All right, now we've looked at the SMJ essay number 1 and thought about organization. So let's try something a little bit different, which is going to be the PJ essay, right? The Y-phone one. This is a wonderful essay. This was prepared for me by my former teaching assistant, we called them ALIs, Brittany Whitnebell. She just graduated, did a wonderful and very prestigious internship with the Florida Supreme Court. That's an opportunity that's available to you guys as well. You should look into that. It's a great opportunity. So this is done by Brittany. I haven't changed the fact pattern except for inserting, I think I added the long-arm statute, and I changed the jurisdiction to South Florida, which is a fictional state. Now here's what we want to do. Our ultimate goal is to think about how are we going to organize this. But to organize this, of course, we got to practice our essay reading and organization skills. So question number 1, what is the first thing you do when you're given an essay question? Okay, good. Let's do that first. It's typically at the end, right? So it says, Bill sued Telephono and Best Batteries. Right? Should the court grant or deny Best Batteries motion? Well, now we have to figure out what kind of motion has Best Batteries done, right? Well, it's a pre-answer motion. It's a timely one to dismiss for lack of PJ. So we know Bill sues Telephono and Best Batteries. So it's Bill versus Telephono and Best Batteries. To make sure that we've put the parties up correctly on the board, we will want to now look at the full fact pattern and start spotting issues with an eye towards PJ. Now, before we do that, let's think about what court we're in. What court are we in? State or federal? We are in federal court. Federal court is a brand new state of South Florida, the 51st state of the U.S. All right. Well, now we're thinking we're in federal court, right? We're in federal court. Now, what do we use for analyzing PJ in federal court? Remember the left-hand side of the cogwheel? What rule do we use for analyzing in personam jurisdiction over a company in federal court? That's right, 4K. So we now start be looking for facts that are relevant to 4K1A, 4K1B, 4K1C, and 4K2. So we're starting to think 4K, right? Now the main one is of course going to be 4K1A. So we know at the very least we're going to have to analyze 4K1A requires us to look at what?
Long-arm statute and the 14th.
Very good. Long-arm statute plus 14th Amendment due process. Very good. So now we already know we're going to have to be talking about those issues, the long-arm statute and 14th Amendment, right? And we might also have to talk about bulge. We might have to talk about the federal long-arm and so on. We're not sure yet, right? We're not sure yet. Do we have the long arm? Is it provided? Yes. It's the full extent of due process. Now, the reason I made this fact pattern, the reason why I changed Britt's fact pattern, is because the way she had written it, it was in Florida. It was filed in federal court in Florida. Federal court in Florida would use the Florida long-arm statute, which is an enumerated long-arm statute. For you to fully analyze that, you would need the actual Florida long-arm statute, which is lengthy, has a long laundry list. If my goal here is to help you build your basic skills, then I'm not going to ask you in this context to analyze the enumerated statute. Instead, I'm just going to give you the easier to analyze unenumerated long-arm statute, and it'll be that much analysis, and then the due process will be the vast bulk of it. Well, let's go to the facts and start seeing what we can find. All right, Bill Byer is from Florida, and as we go from the fact pattern, we'll see that Bill is from Florida, and that fact doesn't change. All right. Bill loves his Y-phone. It's manufactured by Telefono. Telefono is in California with his PPOB in California. All right. So Telefono, California. Great. On August 1st, Bill surfs the internet and sees an ad on Telefono's website, telefono.com. If you see ad, you should start be thinking about, well, is that a contact? Whose contact would it be? It might have something to do with O'Connor's stream of commerce, right? Because that talks about advertising aimed at the forum state. And obviously, we want to read the ad. Pre-order online today, the Y-phone by Telefono, all right? Available in all 50 states. Okay, is the ad aimed at just Florida? Is it aimed at all the states? That's something you should start thinking about. That purposeful availment. Aiming somewhere or everywhere. All right, all pre-ordered Y-phones will be delivered to your front door. Available in 50 states or at your telephone store. Release date September 1, only $500, insurance not included. All right, facts go on. Bill orders the Y-phone on September 1st. He gets it in his mailbox. He opens it up and he gets his glistening new Y-phone 6, right? I guess when Brittany wrote this, the iPhone 6 was big. Now we have the iPhone 7, right? It worked flawlessly for the next few weeks, but on November 1st, and in this fact pattern, dates don't seem to be super important, but in other fact patterns, dates would be super important, right? We'll be talking about relation back pretty soon. Things like statutes of limitations, right? Relation back. Deadlines for filing or for answering, right? Dates become very important. Again, the law determines what facts are material, what facts are relevant. Bill's playing Cabbage Crush, and his device heats up and burns his hands. He goes to ER, sees the news on TV. He learns that the Y-phone 6, the pre-ordered Y-phone 6s contain faulty batteries, and they're being recalled. They are being recalled, all right? So now we're starting to think, now, what is the finished product here? What did he buy? The Y-phone. Who did he buy it from? From Telefono, right? Did he buy it in a store? He bought it online. Online from who? Best Buy? Telefono. Okay, so again, let's think about what's going on here. Here's Bill, the purchaser. He ordered the phone from Telefono online, right? And it was delivered via mail. Now the telephone itself hurt him, right? But why did the telephone hurt him? The battery. Does the fact pattern tell us anything about the manufacturer of the battery? Yes? It does. Best Battery sells cell phone batteries to Telefono and 5 other major manufacturers in the U.S. It's incorporated in New York with its PPOB in New York. Okay, so we go down here, New York, right? It makes and ships 10 million cell phone batteries to its 6 major customers every year. For the Y-phone, it sent 1 million batteries, $20 each to Telefono, all right? Batteries are manufactured in New York and shipped to California to be installed in the Y-phone. Best Batteries does not advertise anywhere outside of New York. Now, whose ad is this? Is this Best Batteries ad or is this Telefono's ad? Okay, there we go. Is this a stream of commerce fact pattern? Is this a stream of commerce fact pattern?
I would say yes,
You would say yes. Yes, because?
because it's going from manufacturer to the distributor.
Yes, the battery is going from Best Battery to telephono, incorporated into the Y-phone, and then shipped to the consumer. All right, best batteries, New York, telephono is California, and it was sent to the purchaser in Florida. Boom, stream of commerce fact pattern, isn't it? All righty, now we have all the facts. You should be thinking there's lots of law here, right? You got, oh man, imagine if you put your rules all together. Remember I said how awful it is to barf out all the rules together and do rigid IRAC? You know, the issue's easy. Should the court grant Best Battery's motion to dismiss for lack of PJ? And the conclusion is going to be yes or no, or yes depending on this, that, or the other, or likely no because this, that, or the other, right? You see, if you do your sub-conclusions, then your ultimate conclusion can be clearly contingent upon all of your sub-conclusions because you made those sub-conclusions. Yes if we use Brennan, no if we use O'Connor, right? Yes, there's PJ if we use Brennan, no if we use O'Connor, so on and so forth. But think that, what if you put all of your law together? You give your issue, is there PJ, should the motion be granted? Now imagine a rule statement that read something like this. To analyze this, we must look to the state of Florida's, to analyze this, we must look to 4K1A, which in turn looks to the state's long arm plus due process. The state's long arm is unenumerated, which means it extends to the full extent of due process. Regarding due process, the applicable bases are blah, 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 blah. Say you concluded specific jurisdiction. For specific jurisdiction, you need 3 steps: purposeful availment, giving rise, and the 5 factors. And then you explain what purposeful availment is. And then you tell me the law for what Brennan said, for what O'Connor said, what Stevens said. And then for giving rise, have we done any analysis yet? No. Then giving rise, you say courts have 2 different tests they use. Some use one, some use the other, some haven't decided. Then you give the evidence in the but-for test. Still haven't done any analysis. And then after that, they do that, the court's got to look at the reasonableness factors, shifting the burden to the defendant under the burden-shifting framework of Worldwide and Burger King. And these are the 5 factors you look at. Now you have a rule statement that's about 2 pages long, right? Maybe 3 pages long. You with me? Have you done any analysis yet? Is that a good way to structure your essay?
No.
It's a really poor way to structure your essay. By the time you do your analysis, you'll have forgotten what half of the sub-issues are. So instead what you do is you determine what issues are raised. Now we know we're going to have to talk about long arm and due process. Do we have to talk about other parts of 4K1A? Is this a bulge jurisdiction fact pattern? No, it's not, because,
There's no other party joining.
well, you don't know Rule 14 and 19 yet. Do we have a defendant who was served within 100 miles of the courthouse? Do the facts even say where Best Batteries was served? No. This isn't bulge jurisdiction. It can't be a 4K1C because we don't have any special statute that we know of that might grant nationwide PJ. Okay. Can we use 4K2? 4K2 applies if you have a federal question, if there's no 4K1A jurisdiction, in other words, there's no PJ over Best Battery in any state, right? And if there's nationwide context. All right, is this a federal question? What kind of cause of action we have? Negligence and products liability, right? State law or federal law? State law. Can we use 4K2? No. You don't even go there. Don't negative issue spot. Don't negative issue spot. Negative issue spotting, the crazy bad kind of negative issue spotting would be, I ask you, is there PJ, and you want to analyze SMJ. And you chuckle, but people do it every year. People do it every year. I guarantee you at least a couple people in the class will do that, and it breaks my heart when I see it. Sometimes it happens because the student panics. Sometimes it happens because the student isn't comfortable answering the question asked, so they hope if they talk about something they're comfortable with, I'll give them points for it. I can't give them points for it, right? You have to problem solve. You got to deal with the question that's asked. A more common kind of negative issue spotting might be analyzing the wrong person. The student starts to explain why there's PJ over telephono. But in the fact pattern, telephono didn't object to PJ. And the call of the question is about best batteries, right? So you don't talk about the wrong party. You talk about the party that's in the call of the question, right? You use the call of the question to tell you what issues are relevant there. A more invidious and easy to make kind of negative issue spotting is talking about issues that are not reasonably raised by the fact pattern. They fall within the scope of the fact pattern, but they're not reasonably raised. So here, that would be like 4K2, for example. There is no way there's 4K2 jurisdiction here. These parties weren't joined, the Best Battery wasn't joined under Rule 14 or 19 for reasons you'll understand we get to joinder. Best Batteries was not, to our knowledge, served within 100 miles of the courthouse in South Florida. There's no 4K2 because it's not a federal question. I think I jumped from one to the other. There's no 4K2 because it's not a federal question, okay? And there is 4K1A jurisdiction over Best Batteries somewhere. Where should Best Batteries be subject to PJ with certainty? New York, right? New York and maybe California, right? New York and maybe California. So because there's 4K1A jurisdiction somewhere, you can't have 4K2, right? And we know there's not bulge because nobody's served within 100 miles, there's no Rule 14 or 19 joinder. That's definitely out. So if there's definitely no PJ, don't even go there. Would you talk about, for example, the tag rule? Can you use the tag rule here? No, because it's a corporation. Best Batteries is a corporation. You can't have tag over a corporation. Don't go down bases that are clearly not at issue. Talk about the ones that are arguable, the ones that are reasonably raised by the facts, regardless of your conclusion, right? So a harder one would be, is general jurisdiction arguable here? Is this something worth raising? General jurisdiction. What do you think? Tell me what you think. How much time do you have? Maybe I give you 30 minutes to do this essay, all right? 35 minutes to do this essay. Do you talk about general jurisdiction? Why not? Do you think general jurisdiction exists? Because, I agree with you, the answer is no. There's no general jurisdiction here. Does Best Batteries have systematic and continuous contacts with the forum state of South Florida? No. Is it, if it doesn't have those contacts, how could it possibly be at home, right? In fact, I would say general jurisdiction here is probably not even worth going into. It's the closest thing, it's the thing that's right there on the line between a non-issue and maybe arguably an issue. But it's just not worth going into, right? It's so clear that there's not general jurisdiction. It's either negative issue spotting or not even worth going there, right? You gotta use your judgment, guys. Use your judgment. Don't try to talk about everything that pops into your brain unless it's reasonably raised by the facts. Now, what about specific jurisdiction? Is that worth talking about? Yes. And for the purposeful availment, what's going to be your main way of showing purposeful availment? What's that?
Minimal contact.
Well, minimal context test includes purposeful availment. How do you show purposeful availment, Patrick?
Three tests with the judges, Brennan, O'Connor, and Stevens.
Yeah, 3 tests concerning what? Stream of commerce, right? All right. Now we think, oh, well, yes, the issues here are going to be 4K1A, long-arm due process, and the due process is going to talk about specific jurisdiction, which has 3 steps, and there's going to be a bunch of sub-steps, right? So now let's start talking about how we'd organize it, right? You see how you're using your, I hate to even use the term, your student experience and your common sense in problem solving based on the call of the question, the facts, and the issues that are reasonably raised by the fact pattern in light of the call of the question, right? You are expected, you're a first semester law student, but nonetheless, you are expected and required to start honing. Don't really like that word, but it's an appropriate word. Honing your problem-solving skills. That's the #1 skill of any lawyer, is problem solving. And successfully organizing and drafting a good IRAC essay in your law school classes is an example of developing those problem-solving skills. So let's talk about how you might organize this essay. All right, so the overall issue, and you have an overall conclusion at the end, right? Overall issue. Should the court grant Best Batteries motion to dismiss for lack of PJ? Overall conclusion we haven't gotten to yet, right? What's the overall rule? What's the overall rule here? Overall rule isn't a 2-page barf out of all the law, right? What is a pithy, succinct overall rule that's going to allow us to then build a structure underneath it? Overall rule is kind of like the foundation for all the sub-issues and sub-analyses that follow. What's the overall rule?
It's like a federal law or state
Okay, well, close. We're in federal court, right? So what part of Rule 4K is going to be at issue here, right? Yeah.
Would be where the federal court has jurisdiction over best batters, or personal jurisdiction over best batters.
No, I'm asking not, that's an issue. You've asked a question. Issue is a question, right? I've asked the overall rule. What are the main parts of your structure going to be?
Specific jurisdiction.
What's that?
Specific jurisdiction.
No, we haven't even, specific jurisdiction is due process, right? Have we gotten to due process yet? What do we have to analyze before we get to due process? 4K, because we're in federal court. So that's going to be 4K. Which part of 4K is applicable here? 1A, 1B, 1C, or 2? Just 1A, which in turn tells us to talk about long arm plus due process. 14th Amendment due process, right? And then we have a sub-issue of the long arm statute, don't we? Now, I'm not going to go into detail on each one. I'll let you flesh out your outline. But for that sub-issue of the long arm statute, you'd have to say, is the South Florida long arm statute satisfied? You'd have to give the rule. You'd have to explain what it means. Now, because that long arm statute is unenumerated, that means that the South Florida legislature has granted its courts the power to exercise jurisdiction over someone if due process doesn't forbid it. So what are you going to have to know in order for you to conclude that the long arm statute authorizes jurisdiction? What's that? What do you have to know? What do you have to know? Whether the 14th Amendment forbids jurisdiction, right? See how they're tied together? It's kind of like you go to one parent, can I stay up late? And the parent says, oh, it's okay if your other parent says yes, right? So if you think of the long arm statute and due process, they're kind of married together in an unenumerated long arm statute, aren't they? Long arm statute says you can stay up late, you can have PJ, so long as due process doesn't say no. So now you have to go to the other parent. Now you have to go to the due process to do that analysis, and that in turn is going to tell you whether the long arm statute is satisfied. That suggests that you could start your long arm analysis at the beginning and then finish it after you do due process, or you could just do due process first and then do the long arm. Both would be proper. Both would be thoughtful ways of organizing. I leave it to you to decide which way to do it. But what I do expect you is to make sure that you tell me that sub-issue of the long arm, explain what the law is, and then your analysis of the long arm here is going to hinge upon what due process says. Say you conclude that due process would not forbid jurisdiction, okay? Well, then your analysis for the long arm statute would be saying something like this. Because the due process clause does not forbid PJ, the state of South Florida's long arm statute grants it. Short and sweet, right? So the long arm statute here is not the big part of your analysis. The second sub-issue, sub-issue 1, sub-issue 2, is going to be due process, right? Now for due process, we concluded that the only basis that's reasonably raised by these facts is specific jurisdiction, right? So sub-issue 2 is going to be due process, which means here we're going to analyze specific jurisdiction, because that's the only way due process will be satisfied, is if there is specific jurisdiction, because no other basis can be satisfied under these facts. All right. First thing you have to do is give the overall, overall rule for specific jurisdiction. What's the overall rule for specific jurisdiction? I don't want the details. I don't want the 5 factors yet. I don't want the give rise and but for test. I don't want all the stream of commerce tests. Just give me the parts of the analysis. We're looking for an umbrella, an organizational framework coming from the overall rule. What would that be?
Purposeful availment?
Okay, purposeful availment. Anything else?
Yes.
First step, purposeful availment.
Context.
No, purposeful availment is showing which contexts count, right? Don't ever analyze purposeful availment and then analyze contacts separately. Purposeful availment is asking which contacts count and are they enough, right? So what's the first step is purposeful availment. All right, what's the second step? No. Yes. Remember, specific jurisdiction is when the contacts give rise to the claim. And go back to the coggle. You see, your coggle gives you the organization. First step is purposeful availment. Second step is that the contacts through purposeful availment gave rise to the claim. And the third is, that's right, the exercise of jurisdiction is reasonable. Boom, 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 1, 2, 3. Guess what you have now? So you have more sub-issues. Sub-issue 1, sub-issue 2, sub-issue 3. Purposeful availment, giving rise, and the reasonableness factors. You see that? Sub-issues within sub-issues. So for due process here, you've got to analyze specific jurisdiction, which means you've got to analyze purposeful availment, giving rise, and the reasonableness factors. Now guess what? Each of those sub-issues in turn have sub-issues. What contacts does Best Batteries have with the state of Florida? What contacts does Best Batteries arguably have with the state of South Florida? What's that? What through the stream of commerce? Yeah, what contacts arguably does Best Batteries have with the state of South Florida? Use the facts.
The purchaser in the phone.
What's that?
The purchaser in the phone.
Well, did Best Batteries put
The white phone.
the plaintiff in Florida? Did Best Batteries put the plaintiff in Florida, in South Florida? No. What of the defendant Best Batteries has some connection to Florida? What is it? The website? Whose website was that? It's Telephono's. If you want to argue that the website is a contact of Best Batteries, that's going to be a bad argument, right? Whose website was it? Telephono's, right? Does the ad say anything about Best batteries? No. That's not a contact of Best Batteries. That's a contact of Telephono. So I ask again, if Best Batteries has any contacts with Florida, put differently, if Best Batteries has purposely availed itself of Florida, how would that be?
Through the stream of commerce.
Through the stream of commerce. What went through the stream of commerce?
The battery plus
The batteries.
finished product gets there.
That's right. The batteries went from the component manufacturer, batteries in New York, to the phone manufacturer, Telefono, California, to the purchaser who purchased the phones and was injured in the forum state of South Florida. Okay? So what we have to ask ourselves is the sale of batteries from New York to California in corporation to a phone that was later sold in South Florida where it burned and injured the plaintiff, does that count as purposeful availment? How many analyses do you have to do on purposeful availment?
3.
3. Brennan, O'Connor, Stevens, in that order, right? Now, I'm not going to go over the law for each of those. We've done that in class. We did that some, I think, last week. I think we did it in the PJ session. We got to do 3 analyses. And look, we have facts that help you argue all 3 of them, right? For Brennan, what do you think? Do you think Brennan would conclude that Best Batteries has purposefully availed itself of South Florida? Yes or no?
Yes.
Yes, right? Best Batteries is selling 1 million batteries. 1 million batteries to Telefono, which is in California. And 10 million around the country, right? Best Batteries, it would appear to be well aware that his batteries are in phones all over the country and indeed all over the world. So according to Brennan, so long as Best Batteries is aware its batteries are being sold in products that are marketed in South Florida, and there are regular and anticipated sales of those products in South Florida, that would be enough. So your conclusion on Brennan, sub-conclusion is you had given the sub-issue of Brennan, right? Give the sub-rule, your analysis, any counter-analysis, which probably here doesn't exist, and sub-conclude, according to Brennan, Best Batteries has purposefully availed itself of the state of South Florida. Now you move on to O'Connor. Now O'Connor, she requires that Brennan be satisfied, in addition have one or more of her plus factors be met, right? So do you think O'Connor would be satisfied? Put differently, would O'Connor conclude that Best Batteries has purposefully directed, in her terms, itself to the state of South Florida?
No.
Probably not, right? Does Best Batteries advertise in South Florida? No. Is there any facts suggesting a sales agent or customer service in the state of South Florida? No. So O'Connor, the answer is probably no. And there's probably not a counter-argument here either, okay? Now we move to Stevens, all right? Do we have facts that help us with Stevens? Volume, value, hazardous nature. Do we have all the facts we need? Volume.
Yes.
How many batteries? 10 million. Were all of those in Y-phones? All of those in Y-phones? No, those were to all 6 of the customers, right? 1 million batteries sold to Telefono, all right? Did all those batteries end up in South Florida? No, you might have to do some estimation here, right? South Florida is probably going to have maybe like, well, I don't know, 1/20th of the population of the United States. That might be a fair estimate. So you speculate. You say, well, assuming the South Florida is about 1/20th of the population, what's 1/20th of 1 million? I actually don't know. But you guys could do math and you figure it out for yourself, right? So let's see, a tenth would be 100,000, 20th would be 50,000, right? You just said that, didn't you? Somebody just said it. 50,000, right? Yeah, 50,000. Okay, 50,000. All right, how much are the batteries value? 50,000. How much are they worth?
20.
Yeah, 20 each. So $20 each. 50,000 batteries worth $20 each. So that's 50,000 times 2 is 100,000 times 10 is $1 million worth of batteries, right? Again, if my math's correct. Am I correct? Yay! All right. So volume high, value high, hazardous. They burn, right? So Stevens appears to be met. So we appear to have then your ultimate sub-conclusion on purposeful availment is yes if the court uses Brennan, yes if the court uses Stevens, probably no if the court uses O'Connor. Do you see how you'd have to do a contingent ultimate conclusion here? That's a good conclusion, right? Because you're actually aware of your sub-conclusions. And why are you aware of your sub-conclusions? Because you made them. And why are you able to make them? Because you organized. You didn't just lump all your analysis together. You gave rules and analysis by the sub-issue, the sub-rule. Okay, so you have your ultimate contingent sub-conclusion on purposeful availment. Now we move into the sub-issue of giving rise, right? The contacts have to give rise to the claim. Now here we have 2 different versions of the law as well. Purposeful availment, we have Brennan, O'Connor, and Stevens. If we're here giving rise, you're going to have the but-for and the evidence test, right? Give you a sub-issue, sub-rule, sub-analysis, and sub-conclusion, right? For each. And even give a sub-conclusion on but-for, or excuse me, on giving rise. You might conclude that, say you conclude the but-for test is satisfied and the evidence test isn't, right? Then you might say the contacts gave rise to the claim so long as we use the one test but not the other one, right? Or you might conclude they're both met, in which case contacts would give rise to the claim, right? Then you go to the reasonableness factors. That involves 2 things. First, there's the burden shifting framework from Worldwide, right, and Burger King, that once purposeful availment is shown, the defendant bears the strong, compelling burden of showing unreasonableness. Then you move into the 5 reasonableness factors, right? The most important of which is the burden of the defendant having to defend in the forum state. Here that would be Best Batteries having to defend in the state of South Florida, right? And I'll tell you that oftentimes when you see very standardish things like reasonableness factors, you might have some real opportunities for argument and counter-argument, right? So don't just throw out an argument and move on in a mad rush to get to the next one. Take a second to think about what argument might each side make. That's I call engaging the legal empathy. You know, here's what what's the plaintiff's name? Bill, right? Plaintiff Bill would argue this, defendant Best Batteries would argue that, right? And maybe sub-conclude and move on. Now, at first this is hard to do, just like the first time you learn how to ride a bike, it's hard to do. This is hard to do in the same sense that learning how to take a car out of gear, okay, and get it on the road, and then accelerate without, and to brake without smacking, jerking your whole body around. That's hard first couple times you do it, right? And now all of you, I would assume, have been driving for 5 years, 10 years, 15 years, 20 years, right? And you do all these things without having to think twice about it, right? You learn by doing. So do. Bring me your essays. I've given you a whole bunch of practice essays. Bring any of them to me. I'd be thrilled to give you feedback on any of them, okay? Bring me hard copy so I can mark it up. I'll mark it up right there and give you feedback, and then we'll talk about it. And don't worry about me marking it all up and telling you all the things that are wrong with it. You could probably bring me the same essay 10 times in a row, and I would still find things to give you comment on, because this is about learning, right? So don't be afraid to come and see me. I'm happy to give you feedback, and it's always in the best of spirit. I want you to develop these skills, and you learn by doing it. Now, let's see how we are on the time. I'll spend, actually, I've only spent about an hour. Let me spend a few minutes talking about the other parts of that handout, the additional drafting considerations. I'll just note some of them. A couple of them are going to be exam advice, some will be time management advice, and I'm going to go through these relatively quickly, and then we'll call it a day. So we're not going to be here till 5 o'clock. First, argue the facts presented. All right? So that means you got to read the fact pattern more than once. Argue the facts presented. Don't get the facts wrong, because you're not going to do well score-wise if you misread the facts or misstate the facts, even if you analyze the wrong facts correctly, right? You misstate the facts and you analyze them well, but those weren't the facts. You're not doing your job, are you? So make sure you're arguing the right facts. Don't change the facts, don't add facts, all right? Subject to a very narrow caveat. If you genuinely believe you have discovered an error in an essay question, please tell me what you think that error is. Tell me how you'd resolve it and how you'd analyze that. Equally so, in the rare circumstance that you genuinely believe that you would need additional facts to analyze the question, right? Like here, do we have the number of batteries in Florida? We don't have that, right? Tell me what additional facts you might need and how they would affect your analysis, right? But in most cases, you're not going to need additional facts. So get the facts right, don't change them, don't add them, unless you're really sure you need to, okay? I've already talked about negative issue spotting. We'll talk about that more later in the semester. Here we go. Don't be conclusory. So if you do the organization the way I've suggested, if you get into that habit of, putting in the keys, putting your foot on the brake, putting in gear, putting on your turn signal, pulling out carefully after looking, right? Doing things methodically and developing good habits, then you're likely not to be conclusory. But a lot of law students write conclusory essays where they just give their conclusion, but they haven't explained how they got from the law to the conclusion. Or they might just give the issue and the conclusion. Or they'll just give facts on a conclusion, right? So if you see me writing down IFC, I'm saying that you've given me issue, facts, and conclusion, but you're not giving me rules and analysis, right? So make sure for each sub-issue you give an issue, rule, analysis, conclusion. Write legibly and grammatically. That speaks for itself. You don't need to cite case names and case statutes. If you're doing stream of commerce and you can't remember whether the case name is Burger King or Asahi, I really don't care. In fact, if you get confused and can't remember which justice had stream of commerce plus, please don't freak out during the exam. What I want to see you write is the law. You can't just say, oh, there's diversity jurisdiction, C-1332A1. That's not a rule, that's not analysis, that's a conclusion, right? With no rule or analysis at all. There's clearly stream of commerce, purposeful availment. See what Brennan had to say in Asahi. So no, that's not a rule. Give me the law. And you don't have to cite case names. You don't have to cite rule sections. You can if you want to. I really don't care. I'd say don't even bother citing. Don't worry too much about citations in an essay, because it'll just slow you down. But you do have to give me the law, right? You'd have to analyze the law. In my exams, always read the instructions carefully. There's always instructions at the beginning of the exam. Read them super carefully. If you're doing a blue book, write on every other page. and skip every line. That gives you the ability that if you want to pencil something in, you can write on the opposite page and pencil in, or write above or below a line. If you forget that rule, and that rule is to help you and not me, if you forget that rule, please don't scratch everything out and start again. Just write down oops, and then start doing it right, okay? It's no big deal, all right? It's no big deal. People forget, but it's to help you so you can pencil stuff in. Oh, what did I just do there? Obviously, read the questions carefully. You should outline before you start to write. Regarding time management, watch the clock and see my instructions. I'll always tell you in the exam how much time I suggest you use for each essay question. And we'll tell you how much time I suggest you use for the multiple choice or short answer questions. And the score for each portion of the exam is generally going to be proportionate to the time that's allotted. Use your time carefully. If I have, say, 2 essay questions on an exam, and say they're both 45 minutes, all right? And now you're at the 70-minute mark and you haven't even finished question 1. You need to do both questions to get a good score, don't you? Budget your time. Make sure you finish the exam. The hardest thing for newbies to do in an exam is to finish it, particularly essay exams. So say you're that student who wrote a beautiful answer to question 1 but never got to question 2. You know, then you end up in my spreadsheet as a DNF student, did not finish, okay? If you're DNF, you don't finish, you're probably not going to get a good score, even if you wrote a brilliant question 1 essay, because you never got to question 2. Because no matter how brilliant your essay may be, it's still a law student essay, and you're likely to still miss issues or get things wrong or make mistakes, right? So even no matter how good 1 question is, you're going to be hurt by not finishing. Finishing is the #1 key thing to doing well in any exam, whether it's, you know, my exam or the bar exam. So don't use your time on 1 question. Know your doctrine well. Don't memorize the law. Well, what I mean is don't memorize the rules and statutes. I provide you with the rules, statutes, and Constitution. You do need to know the case law, okay? Because I don't give that to you. I'm not going to give you a copy of the U.S. reports for your exam, all right? But you got to really know it all already. And knowing the law doesn't mean that you have memorized it. Knowing the law means that you understand it, that you can craft an organized and cogent rule statement, that you can analyze, you can give me meaningful analysis and, if appropriate, counter-analysis on that law as applied to the facts, right? Now, I give you the rules and the statutes and the Constitution mostly as a crutch during the exam to help you, right? Because I don't want people worried that they have to memorize all these long statutes, right? But the truth is that you shouldn't be reading the statutes for the first time during the exam. If that's what you're doing, is the first time you're taking a close look at the statutes and the rules, and it's during my exam, you're not going to do well, even if you're good at reading rules, because you're going to run out of time, right? So the rules are there if you need them, but you should really just know all this stuff ahead of time. Finally, you know, outlining. I think that implicit in the presentation we've done today, and this skills and context session from today, you need to outline before you start to write. What is the overall issue? What's the overall conclusion? What's the overall rule? And what are the sub-rules and sub-analyses? You have it all structured out. Now, if you're typing, you can just type all of that into your paper, right? And then as you're writing, turn your outline into your essay, right? Now, if you're running out of time, you know, write down in the context of your essay, whether it's in paper or whether it's in computer, in the context of your actual answer, if you're running out of time, just give me a quick bullet points of what else you would have covered. And even though you didn't have time to finish, I may give you partial points for the things that you intended to say, all right? But more fundamentally, that outlining before you start to write means, yeah, you've used up this much time to outline, but as a result, you're able to like really blow through very quickly all of the issues. And if you outline before you started, you realize that, hey, some of these issues are big, some of them are small, and then you don't spend a lot of time wasted on small issues, right? Finally, one of the benefits of outlining is you can then turn your outline into subheadings, right, when you're writing. Think about how beautiful your essay is going to look, say for the PJ one, right? You know, overall issue, overall rule, You know, your first issue is long arm, right? Second issue is due process, right? And then under that, you start talking about specific jurisdiction, and then under that, you have subheadings for purposeful availment, giving rise, and reasonableness factors. And if you want to go all gaga, you can even have subheadings below that, right? Don't worry about how many pieces of paper you use. That's not your problem, right? When you use headings and subheadings, that helps you to further organize, it helps you to avoid missing issues, and that helps you to write better, you know, to stick to that. I'm going to IRAC every sub-issue. Okay. So that's all I have to say right now. Before we part for the afternoon, does anybody have any questions? There being none, you guys have a great afternoon. I'll see you soon. Thank you.